Hello. Okay. I'd like to take you to the Legal Metrology Act and the rules. I would basically be concentrating on the Legal Metrology Act, read with the packaged commodities rules. Uh, you know that there are a lot of rules which have been passed in the Legal Metrology Act. For example, the Legal Metrology Approval of Model Rules, the Legal Metrology National Standard Rules, the Enumeration Rules, the Indian Institute of Legal Metrology Rules, etc. But for our purposes, I think as corporate houses, as business houses, as houses which are associated in one way or the other in dealing with various commodities and dealing with various kinds of services, I will be concentrating more on the Legal Metrology Act, read with the packaged commodities rules. So if there is any question that you might have with respect to any of the other rules, I'd like to take it in the question and answer session, or if you'd like to ask me offline, even that is possible. So basically, let me take you through the first slide. I thought it's important to give a perspective to this enactment. So basically, the perspective to this enactment would best be done by comparing it with the earlier enactment. So the Legal Metrology Act, in short, we're going to call it the LM Act in this session, replaces the Standards of Weights and Measures Act 1976 and the Standards of Weights and Measures Enforcement Act 1985. The Legal Metrology Act here, for the first time, entails appointment of government-approved test centers for verification of weights and measures, and wrongful reporting will result in penalties. Basically, earlier the verification of weights and measures was done by the Legal Metrology Department by itself, but now this is thought to be handed over by the state government to the recommendation of the central government to government-approved test centers, which will undertake the verification of weights and measures. The imported weights and measures cannot be used in India under the Legal Metrology Act without being subjected to verification. That's the third point. The fourth point is import of non-conforming standards weights and measures is prohibited even if it is part of the component of a machine. So earlier, if it was a standby, if a standalone weight and measure, it was prohibited, but now even if it is a component of a machine, it is prohibited. The company is to authorize one of its directors as the person responsible to prevent offences under the LM Act after taking the director's consent. This was not there earlier. Earlier, it was the director who was in charge, or the employee who was in charge, or anybody to whom vicarious liability could be fastened would be the person who is going to be responsible. But now this LM Act allows for the authorization of a director who will be the person who will be responsible to prevent offences under the LM Act. The new Act has stringent penalties in place. So unlike the earlier Act, you have a situation where the second and the consequent penalties could extend up to rupees 1 lakh or 1 year imprisonment or both. The notable points under the Legal Metrology Act. The Legal Metrology Act provides for establishment of uniform standards of weights and measures to regulate trades in weights and other goods which are sold or distributed by weight, measure, or number. Now, we are basically looking at this enactment from the perspective of people who manufacture weights and who are involved in various in the trade of different types of weights and measures. The central government may appoint a director of legal metrology to perform duties related to interstate trade and commerce. The state government may appoint a controller of legal metrology to perform duties related to intrastate trade and commerce. So you have two authorities. You have Director of Legal Metrology for interstate trade and commerce and the Controller of Legal Metrology for intrastate trade and commerce. A person has to get approval of the model of a weight or a measure before manufacturing or importing it by the competent authority. So hence the importer has to register under the Act. Here we are talking about the importer of a weight or a measure. Every manufacturer, repairer and seller needs to obtain a license from the respective controller. The LM Act provides the rules to be framed by both the central and the state governments. The points for discussion in today's session, we would be dealing with some important subjects and confining it to those subjects because these subjects are the ones that are going to impact business houses on a day-to-day basis. Number one, usage of only standard weights, measures, and numerals. 2. Regulations to be followed by manufacturers, importers, dealers, and repairers of weights and measures. 3. Verification of weights and measures. 4. Provisions related to pre-packaged commodities. 5. Provisions related to compounding of offences. 6. Offences made by a company. Going on to the next slide. So what do we mean by usage of standard weights, measures, and numerals? Section 4 and Section 5 of the LM Act provide that every unit of weight or measure shall be in accordance with the metric system and based on the international standards of units. So Section 5 provides us with the base units of weights and measures. It says that it gives the different base units, saying the length shall be, the base unit of length shall be the meter, the base unit of mass is the kilogram, etc., etc. So this is just to give an overview of the base units, since this is the base on which the LM Act is actually built. So next slide. Regulations to be followed by manufacturers, importers, dealers, and repairers of weights and measures. Now here again we're talking about weights and measures and people who deal with weights and measures especially. So every manufacturer, dealer, and repairer of weights and measures will require license from the controller of the state. Failure to obtain a license will attract penalties. Importers of weights and measures need registration with the Government of India. Non-registration is a punishable offence. Only standard weights and measures may be imported. So when you say standard weights and measures, we mean the standard weights and measures as recognized under the LM Act. A pound is not a measure that is recognized under the LM Act. So a measure of a pound cannot be imported. Manufacturers, dealers, importers, and repairers shall maintain registers in prescribed formats and produce the same before the authority when called for. Failure to do so will attract penalties. All weights or measures and capacity measures up to 20-liter capacity will require approval of model before manufacturing or importing. However, there are some exceptions to this. Cast iron, brass, bullion, or carat weight, beam scales, length measure, they do not require approval. This heading is under verifications of weights and measures. Here, all unverified weights and measures are liable to be forfeited by the state. Point number 1. Point number 2, weights and measures which require verification before use in any transaction or for protection as defined. So weights and measures require verification. So before you use any weights and measures, you need to have it verified. And when you say protection, it means that when you're using a weight and measure for a particular purpose in trade or business, it's called using the weight and measures for protection. And in such case also you will need to have the weight and measure verified. It is a punishable offence to sell, deliver, or use any unverified weight or measure. Weights and measures used by factories for production of arms and ammunition, for the army, used for scientific research, and exclusively for export do not require verification. Now we come to the next heading, provisions related to pre-packaged commodities. These provisions directly impact business houses because of the trade in commodities, different packaged commodities that are traded in the market today. So coming to the first point, there can be no manufacture, packing, selling, import, distribution, delivery, offer, exposure, or possession for sale of any prepackaged commodity unless the package is of standard quantities. So we need to have to note here the word standard quantities and bears thereon declaration prescribed under the legal metrology packaged commodities rules 2011. For short, we are calling it rules. So there are standard commodities that have been mentioned under the schedule to the packaged commodities rule, which will have to be followed. The second schedule gives different commodities and the quantities in which they have to be packed. We had an amendment to the second schedule as late as 2010 is this amendment, and as per this, we have commodities like baby food, weaning food, biscuits, etc., which have been added, and quantities in which they have to be packed. They can be packed in, for example, baby food can be packed in commodities of 25 grams, 50 grams. Weaning food can be packed below 50 grams. There is no restriction. Above 50 grams, you can be packed in 50 grams, 100 grams, etc. So you have different quantities, and these quantities need to be scrupulously followed while doing the packing. Point number 2, every manufacturer or packer or importer of packaged commodities requires to register under the rules within 30 days of starting business. Point number 3, any advertisement mentioning the retail price of a prepackaged commodity needs to contain a declaration about the net quantity or number of the commodity contained in the package as prescribed under the legal metrology packaged commodity rule. So one has to be careful here while advertising a particular product. You need to ensure in some manner in the advertisement, if you mention the retail price of the commodity, you also need to mention the net quantity or number of the commodity in the package. No prepackaged commodity shall be packed with error in net quantity beyond the limit prescribed in the first schedule of the legal metrology packaged commodities rules. All prepackaged commodities must conform to the declaration provided thereon as per the requirements of section 18.1. There must not be any false declaration. So just to give you a definition of prepackaged commodity, a prepackaged commodity means a commodity which without the purchaser being present is placed in a package of whatever nature, whether sealed or not, so that the product contained therein has a predetermined quality. So when you're buying a prepackaged commodity, you're not able to see it. It's there in the package. So you need to know what is there in the package. You need to know what is the quantity in it. If there is a number to it, what is the number of commodities that are there in the package. Because otherwise there is no way you will know what is there in the package. So that is why it is called a prepackaged commodity. You're looking at some precedents here. In a Supreme Court case, Whirlpool of India Limited versus Union of India, this was decided in the year 2008. The question arose whether refrigerators are a prepackaged commodity. Now, the Supreme Court held that a refrigerator is covered under the term prepackaged commodity. So, you have a particular exemption under the prepackaged commodities rules, which allow for the particular product to be tested, to be opened and tested. So the fact of opening and testing it will not stop a particular commodity from being a prepackaged commodity, because the exemption applies. So even if the package of the refrigerator is required to be open for testing, the refrigerator would continue to be a prepackaged commodity. And since the sale of the refrigerator is a retail sale, the sale price should be printed on the pack. There was, in another case, which was also a Supreme Court case, decided in 2011, State of Maharashtra and others versus Subhash Chandra Kataria. Hello. I think there's some problem in people listening to me, I hope.
We are
you able to hear me?
Yes, sir. Please go ahead. Yes, yes, very much we are able to hear you. Please go ahead.
Okay, okay. So, okay, in state of Maharashtra versus Subhash Arjun Das Kataria, the question arose whether sunglasses were a prepackaged commodity. So here the Supreme Court held that sunglasses could not be a prepackaged commodity since the value of the product cannot be altered or modified on being opened from the package. Now ordinarily, one of the parameters that are used to check whether a particular product is a prepackaged commodity or not is to see whether the product in any way can be altered after it is opened. For example, if it is a tin of Horlicks, a bottle of Horlicks, once it is opened, the contents of it can be reduced, or the contents of it may change after a specified period of time. But if that is not the case, and if an item is kept in a prepackaged commodity, the item is kept in a package, and the opening of the package is not going to alter the item that is kept in the package, that is one of the tests of determining whether the package can be called the commodity can be called a prepackaged commodity or not. So sunglasses, using that test, has been held as not a prepackaged commodity. There are some exceptions to the rule, these rules on prepackaged commodities, which normally apply to prepackaged commodities. Basically the rules which apply to prepackaged commodities are rules relating to the declarations on the display panel, and the rules regarding the quantity and the volume. So these will not apply in certain cases. Those exemptions are provided here. Net weight or measure of the commodity is 10 grams or 10 ml or less if sold by weight. Sold by weight or measure. Fast food items packed by restaurant or hotel. Scheduled and non-scheduled formulations covered under the Drug Price Control Order 1995, made under Section 3 of the Essential Commodities Act. Agricultural farm produces in packages of above 50 kilograms. Now, classification of packages. Under the packaged commodities rules, packages have broadly been classified into three types. They're basically retail packages, wholesale packages, and packages for industrial or institutional customers. So, retail packages. Retail packages are items listed under the second schedule, which have to be packed in quantities specified in that schedule. So unlike the earlier enactment, the schedule now offers wider options. If a commodity specified in the second schedule is packed in a size other than what is mentioned in the schedule, a declaration not a standard pack size under the legal metrology package commodities rules or non-standard size under the legal metrology package commodities rules shall be made prominently on the label of such package. So a particular commodity needs to be packaged in 50 grams, 100 grams, 200 grams, etc. But if that particular package is not packaged in those particular numbers, but is packaged probably in say 25 grams, then you need to put a declaration on the display panel saying that it's not a standard pack size. Items not included in the second schedule may be packed in any quantity or sizes. So if you are trading with a product, manufacturing a product which is not mentioned in the second schedule, you can pack it in any quantity or size. When one or more packages intended for retail sale are grouped together for being sold as retail package on promotional offer, every package will need to adhere to the declaration requirements to be made on each package. So this is as per the Amendment Rules 2012. It is permitted to pack value-based products of ₹1 to ₹10, bypassing the second schedule. However, the declaration requirements in Rule 6 need to be met. So you have these value-added packets. For example, you have packets of coconut oil, or similar such packages, which are normally released in value packs. Sometimes you get these tea packs, etc. So these packs can only be released in values of ₹1 to ₹10. So these packages can only be issued in values of ₹1 to ₹10, and this is bypassing the second schedule. However, you need to mention all the declarations mentioned in Rule 6 need to be met. So we'll come to the declarations that have to be mentioned in Rule 6 in the later slides. Going on to wholesale packages. What are wholesale packages? Packages intended for sale to an intermediary and not to a single consumer directly, and which contain several retail packages or bulk quantity for direct sale in smaller quantities. So it is not for any one single consumer, and it is normally sold to an intermediary, and it contains several retail packages, or it contains a bulk quantity for direct sale in smaller quantities. So that's what it is. So you can have these cement bags or rice bags which are in bulk quantity, but later on are sold in smaller quantities. Packages for industrial or institutional customers. The rules with respect to packaging and principal display do not apply to institutional consumers or industrial consumers under specific circumstances. We mean industrial and institutional customers. We mean consumers in the transport and the hospitality industry, like hotels, hospitals, railways, etc. Now we come to Rule 6 basically. What do you mean by having to put your statutory declaration on the retail packages? So we're only talking about retail packages here. First of all, you need to mention the name and address of the manufacturer, the name and address of both the manufacturer and the packer if they are not the same, or the name and address of the importer in case you are importing a particular item for sale in India. Where any commodity manufactured outside India is packed in India, the package shall also contain on the principal display panel the name and complete address of the packer or the importer in India. So then, if you are importing a package, you need to mention the complete address of the packer or the importer in India. The common or generic names of the commodity. For example, common salt or sodium chloride should be contained in the package, should be mentioned in the product, in the package. And if you have a package which has more than one product, the name and number or quantity of each such product shall be mentioned on the package. The net quantity in terms of the standard unit or weight or measure, standard unit of weight or measure of the commodity contained in the package, or where the commodity is packed or sold by number, the number of the commodity contained in the package shall be mentioned. So as mentioned earlier, you need to mention the number of the commodity in case the package, you're not able to mention a particular weight for that particular commodity, and if the commodity has a particular number, then you need to mention the number of that particular commodity. For example, a matchbox has 50 matchsticks. You'll have to mention that there are 50 matchsticks in that matchbox. It will be difficult for you to mention how many grams of matchsticks are there. It is easier for you to mention the number of matchsticks in that matchbox. So there you'll have to give the number of the commodity contained in the package. The month and year in which the commodity is manufactured or pre-packed or imported shall be mentioned in the package. The manufacturer may indicate the month and year using a rubber stamp without overwriting. So using a rubber stamp without overwriting is allowed. The month and the year in which the commodity is pre-packed may be expressed either in words or by numerals, indicating the month and the year, or by both. For example, June 2014. You can either mention it as 06.14 or you can mention it as June 2014. Now this requirement is not required for seeds, which will be governed by the provisions of the Seeds Act. Every package is to bear the name, address, telephone number, email address of the person who can be, or the office which can be contacted in case of consumer complaints. So you'll have to mention in case of consumer complaints, for example, consumer care, you need to mention a number, you need to mention a email. So this is part of Rule 6. Do not affix individual stickers on the package for altering or making declaration required under these rules. However, if you reduce the maximum detail price, a sticker with the revised MRP, revised lower MRP, inclusive of taxes, may be affixed, and the same shall not cover the MRP declaration by the manufacturer or the packer. Now this Rule 6 talks about a situation where you reduce MRP. It doesn't talk about a situation where you increase MRP. So if you reduce MRP, you can have a sticker with the lower MRP affixed, and the same will not cover the MRP declaration by the manufacturer or the packer. So there's a case on this. This is a Philips Electronic India Limited versus Government of AP. So the question arose. This came before the High Court of Andhra Pradesh. The question arose on whether affixing a rubber stamp on the package stating the retail sale price is permissible or not. So here the price was altered by putting a rubber stamp, by affixing a rubber stamp, and the packages were seized by the officers of the Legal Metrology Department, stating that the affixing of a rubber stamp does not constitute a label under the packaged commodities rules, and hence a case was slapped on the company. The Honorable High Court referred to Section 2F of the Act, which defines label as any written, marked, stamped, printed, or graphic matter affixed to or appearing upon any prepackaged commodity. The rubber stamp constitutes a label for the purposes of the Act. Since the definition of label says that anything stamped can also be a label, the court held that the rubber stamp constituted a label for the purpose of the Act. The High Court came down heavily on the officers of the Legal Metrology Department who seized these products, stating that the act of seizure of the product was negligent and illegal, and costs were imposed on the errant officials. Where a commodity consists of a number of components, and these components are packed in 2 or more units, for sale as a single commodity, the declaration is to appear on the main package, and such package shall also contain information about the other accompanying packages, or such declarations may be given on individual packages, and intimation to that effect may be given on the main package. So if you have a situation where you have a particular commodity which cannot function without different commodities being attached to it, you will have to have the principal display panel mentioning each of these commodities either separately on one package which covers all of these commodities together, either on one package, or separately on each of the packages which make up one commodity. So you have multiple commodities making up one commodity. For example, if you have a music system which has an amplifier, a headset, a microphone, speakers, you either put it all in a box and have one labeling for the whole box mentioning each of the items inside it, or you have display panels for each of the separate items, pack each of the separate items separately, and make a mention in the main box stating that the legal metrology package commodities rules has been complied with, and the requirements of the display panel with respect to various requirements on the item, the price, etc. is individually mentioned in each of the commodities. The declaration of quantity in relation to commodities which are likely to undergo significant variations in weight or measure on account of environmental or other conditions may be qualified by the words when packed, as specified in the third schedule. So if you have, today you have items like vegetables and fruits also being packed, so you need to mention what the quantity is as on the date of packing, and you need to qualify it with the words within quotes when packed, because these are items which could undergo variation over a period of time. Every package containing genetically modified food shall bear at the top of its principal display the words GM, which means genetically modified. So this is as per the amendment rules which were issued in 2012. Statutory declarations. This is again for retail packages. Where are they supposed to appear? So every declaration on the rules are to apply on the principal display panel. So we will talk a little more about the principal display panel as we go on in the session. The area surrounding the quantity declaration should be free from printed information, at least to the extent of above and below by a space equal to the height of the numeral in the declaration. To the left and right by a space equal to twice the height of the numeral in the declaration. So basically, if you were to have the principal display panel, which is affixed on a packaged commodity, and if you were to have numerals printed there, which numerals are not to exceed a certain size as per the rules, you will have to mention, you will have to ensure that there is a certain gap on the top and a certain gap on the sides of the display panel. Certain gap on the top and the bottom, and certain gap on the sides of the display panel. So above and below, the space will should be equal to the height of the numeral, and to the left and right the space should be equal to twice the height of the numeral. Now, if you actually go to rule 8, so the package commodity rule, I'm just looking at it. So here, rule 8 says that every declaration required to made shall required to be made under this rule shall appear on the display panel, and it says what it just said. If you just go little above, rule 7 talks about the principal display panel, its area, size, etc. And there it gives the height of the numeral. It mentions in table 1 what the, if you mention the net quantity as shown in table 1, how you should mention the height of the numeral. It is net quantity in weight or volume up to 200 ml. If it is up to 200 ml, the minimum height in millimeters, in normal case 1. If it is just a package which is normal, it should be 1 mm. In case it is blown, formed, molded, embossed, or perforated on the container, if the package, the principal display panel has not been fixed in the normal manner, but has been fixed in a manner that is molded, etc. In order to make up for the variation in the form, it has to be 2 mm in size. If the quantity is 200 grams, if the net quantity in weight or volume of the particular packaged commodity is 200 grams, above 200 grams and below 500 grams, then the height in millimeters will have to be 2 mm, and where it is embossed or perforated, etc., etc., it has to be 4 mm. So you have the minimum height of the numeral, which is given in shape P1. In table 2, also you have the minimum height of the numeral. If the net quantity is declared in terms of length, area, or number. So in table 1, if the net quantity is declared in terms of weight or volume, you have the net quantity, you have the minimum height numeral, as I just mentioned. In table 2, if the net quantity is declared in terms of length, area, or number. So there you have the different heights of the numerals which have to be mentioned. So if the net quantity is up to 100 centimeter or 100 square centimeters, the minimum height in numeral will have to be 1 millimeters. Where the net quantity is above 100 square centimeter or below 500 square centimeters, the minimum height will have to be 2 millimeters. When the packaged commodity label on the packaged commodity is formed, molded, etc., it has to be 4 mm. So you have different sizes which you need to maintain depending on the principal, the net quantity in length, area, or number of the principal display panel. So once you have fixed it, this numeral, the size of this numeral will have to be taken into account in order to ensure that the surrounding area around which the principal display panel, surrounding area around the principal display panel does not exceed, is at least, is not less than the amount that is specified in terms of the size of the numeral. For soft drink, ready-to-serve beverages or the like, the retail sale price may be indicated herein on the crown can, or on the bottle, or on both. It is sufficient to indicate the retail sale price in the form of MRP rupees dash. So you have the principal display panels and where they have to appear in different circumstances. You have the height that is mentioned. The size of the principal display panel, of course, is not mentioned. However, they have stated that the size of the principal display panel will have to, in any case, it can be of any size, but there will have to be a gap between the principal display panel and the borders of the area in which the principal display panel is stuck, which gap between the principal display panel and the borders of the area should not be less than the height of the numerals as specified in the tables 1 and 2, which is under Rule 7. So now these statutory declarations, how are they supposed to appear? The declaration should be legible and prominent. The numerals of the retail sale price and net quantity declaration shall be printed, painted, or inscribed. They should be inscribed on the package in a color that contrasts conspicuously with the background of the label. The particulars of the declarations required to be specified shall either be in Hindi, in Devanagari script, or in English. So if you have the principal display panel in a certain color, it needs to contrast conspicuously with the background of the label. That's why in many cases you've seen the principal display panel being in white and the background color being in blue or dark blue or something of that nature. You've seen the principal display panel being in yellow also in certain cases. So the whole idea is to ensure that it stands out and there's a contrast between the principal display panel and the background of the label. We now come to wholesale packages. What are wholesale packages? Wholesale packages are intended for sale to an intermediary and not to a single consumer directly. So you don't sell wholesale packages to a single consumer directly. You always sell it to an intermediary, and it contains several retail packages, as I've already said earlier, or bulk quantity for direct sale in smaller quantities. So it could be a big retail package containing of cigarettes, or it could be a big retail package, as I using my earlier example of matchboxes, it could be a big box of matchboxes. So now that is a wholesale package, since it contains about say 50 matchboxes, and this is a wholesale package. So what do you have on the wholesale package? What do you put on the wholesale package? The name and address of the manufacturer or importer. If a separate agency is used for packing, the name and address of the packer. The identity of the commodity. You need to say what is it. It's a matchbox. So matchboxes are there in that wholesale package. So mention matchboxes. The total number of retail packages contained, or the total number, quantity or number contained in the wholesale package. So if there are 50 matchboxes, say 50 matchboxes. The declarations must be legible, definite, plain and conspicuous. It has to be legible. It cannot be smudgy, or it cannot be written in a way that is not understandable. Wholesale packages may be packed in any quantity and need not declare MRP, date of manufacture, or address, telephone, etc. of the consumer complaint department. So all this will not need to be stated on the main package or the wholesale package. However, the inner retail packages should mention all of this. So everything that we just spoke about in Rule 6, in the previous slide, will have to bear mention in the retail packages which are inside the wholesale package. So we come to Delhi High Court decision passed in 2008. There was an inspection carried out at a distributor store by the legal metrology officials, and the complaint was filed against the manufacturer for not printing the price of the cigarettes on the packet. So the issue was raised on whether it was a wholesale package was required to display the maximum retail price. Now, a wholesale package is not a retail package, as we already discussed. So wholesale package did not mention the retail price. So that's exactly what the Delhi High Court held as well. Delhi High Court said that wholesale packages did not contain the information that is required to be stated on a retail package. There is no requirement to state the retail prices on the wholesale package. Now we come to the third type of packages, packages for industrial or institutional consumers. Here, the rules with respect to packaging and principal display panel do not apply to institutional consumers or industrial consumers under specific circumstances. So you need to notice the rider specific circumstances, and we'll come to it later. Institutional consumer means institutional consumers like transportation, airways, railways, hotels, hospitals, or any other service institutions who buy packaged commodities directly from the manufacturer for use by that institution. So all of these institutions like airways, railways, hotels, hospitals, they buy packaged commodities directly from the manufacturer. And they buy it from the manufacturer, that is number one. And number two, they buy it for use in that institution, not for further resale. So when they buy it for use in the institution, then they are called an institutional consumer. Industrial consumers are industrial consumers who buy packages directly from the manufacturer for use by that industry. So you have industrial consumers like big retail stores, like big retail stores who buy packaged commodities directly from the manufacturer for retailing the products in their industry. It could be fridges, fridge, TV, or whatever that is. However, the rules regarding display and packaging will be applicable to all industrial or institutional consumers who buy the product from an entity other than the manufacturer. So if the retail stores or the hospitals, as the case may be, or any other industrial consumer, they buy the product not from the manufacturer but from a stockist or a distributor, then the rules regarding display and packaging, which is mentioned under Rule 6, will be applicable even to these packages which are being used by institutional customers and industrial consumers. We next come to export or import of packages. Export of packages do not require to be registered under the rules. The rules regarding packaging and display do not apply to packages meant exclusively for export. Such packages cannot be sold in India unless repacked to conform with the rules. Import packages. Importers of packages need to be registered under the rules. So all importers who are going to import any commodity and who are going to sell that commodity in India will have to ensure that they are registered, number one, and that they have to that the products that they sell here are compliant with all the provisions under Rule 6 with respect to display and with respect to having to follow the standard standard quantity and quality contained in the package. We have a Supreme Court case here on this point. So this case is MS India Photographic Company Limited with H.T. Shourie. Here the consumer had complained that the appellant was selling Kodak films without the price printed on it. So this is an interesting case where you had a consumer who was complaining that there was no price printed on the Kodak films which were being sold, and the Supreme Court said that the provisions of the statutory declarations have to be complied with. And the reason that it gave for this was that it said that this was, number one, to discourage distributors of foreign goods from making obscene profits, because we never know at what price these products were actually bought. And Number two, in the interest of consumer safety, letting the consumer know that this is the actual price and this is the net contents of the package that is being sold. So in a way, the case was presented in a manner that made it look as if the Supreme Court was inclined towards the interest of the end consumer. We now come to provisions relating to compounding of offences. Offences may be compounded before or after the institution of a prosecution on payment of a prescribed sum. So, what is compounding basically? If you go down, there's a small handlebar which basically says compounding is a settlement whereupon the authority agrees not to report the occurrence of an offence or not to prosecute the alleged offender in lieu of payment of the compounding amount fixed by the authority. So, compounding is a settlement whereupon the authority does not report the occurrence of the offence and does not prosecute the alleged offender in lieu of payment of the amount which is fixed by the authority. So who can compound offences? The director or the authorized legal metrology officer may compound offences for certain provisions of the Act. This amount is, however, not to exceed the maximum amount of the fine which may be imposed under this Act for the offence so compounded. So basically, the amount which has to be considered for compounding the offence is normally stated in the legal metrology enforcement rules, which have been passed by various states, and this could vary from state to state. But in any case, it is not to exceed the maximum amount of fine which may be imposed under the Act. Next point, the controller or legal metrology officer authorized by him may compound offences punishable under certain provisions of the Act. Such sum shall not in any case exceed the maximum amount of fine which may be imposed under this Act if the offence was so committed. So you have the director who can compound certain offences, you have the controller or legal metrology who can compound certain other offences. So depending on the seriousness of the offence, these offences have actually been segregated into offences which can actually be compounded by the director or the authorized legal metrology officer or the controller of the authorized legal metrology officer. The compounding of offences is not possible if another same or similar offence is committed within 3 years of the first offence. So after the 3 years of the first offence, compounding is again possible. But if the offence takes place within the first 3 years of the first offence, then compounding is not possible. We come to offences. So who commits these offences? How are offences taken cognizance of? So normally these offences are committed by companies because business houses are normally form themselves into a company. But the definition of company is pretty wide under the Legal Metrology Act, and it can also include a firm, etc. So in that sense, it does not have to actually be a company constituted under the Companies Act. So when no person is nominated, so basically, okay, coming to the first point, a company may nominate one of its directors with this written consent who will be responsible for the conduct of the company. Notice of such nomination may be given to the director or the concerned controller or legal metrology officer. Now this is a point which is not there under the earlier Act. Here you have a situation where the company can nominate one of its directors provided the director has given his written consent, and the director says, okay, I will be responsible to ensure that there is no offense under the Illegal Metrology Act which will be committed by the company. The director gives his consent, and this consent is brought to the notice of the director or the concerned controller or legal metrology officer. Now, this is a new introduction that's been made into this act. It's a welcome introduction, but going from precedents that have been held in the past, we do not know to what extent this introduction, the enactment, is going to be effective. We'll come to this a little later. So let's going on to the next point. The nominated person and the company itself will be held responsible for violation of the provisions of the Act. So the particular rule says that the nominated person and the company itself will also be responsible for violation of the provisions of the Act. Where no person is nominated, the person who is in charge or responsible to the company will be held responsible. Even if a person is nominated, any other person responsible to the company and due to whose consent or negligence the violation has taken place will also be held liable for any offence committed. So, even if a person is nominated, it can be shown that there's another person who is actually responsible for the offence, then in addition to the person who has been nominated, the person who is also responsible for the offence will also be responsible. When a company is convicted, the company may direct the court may direct the company to publish its name and the offence committed by it in the newspapers at the cost of the company. So this provision was there under the earlier enactment as well. So this is a kind of deterrent which allows the court to direct the company to publish its name and offence committed by it in newspapers, and this will be done at the cost of the company. This is only, however, it has to be noted that this is only in case the company has not yet filed an appeal, or that is the period of appeal has expired. So during the period of appeal, the company still has the option to be able to go on appeal, and this requirement to and during this period the court will there is no need for the company to give effect to the court's directions to publish the offence in the newspaper during the period that the company can go on appeal. However, the company has not gone on appeal, the company will have to go by the directions of the court and publish its offence in the newspapers. There is a precedent in this regard which I refer to in the first point, which I'd like to come back to now. So you have this particular Kerala case where the Honorable High Court of Kerala held that there needs to be specific averments to attach criminal liability based on the principles of vicarious liability in order to prove that a person in charge of and responsible to the company for the business of the company is actually responsible for the offence. So unless you're able to prove that a person is actually responsible, there are enough precedents in this regard. Even if there is you have this particular section 49 in the Legal Metrology Act, which says that a particular director can actually be appointed and made responsible for the acts of the company. This could be challenged in a court of law, and if the company is able to prove that the particular director, although he is nominated, was not actually responsible for the offence that was committed, then there is a good chance that the director will not be called up. Now coming to the analysis and conclusions on this presentation that we've just gone through. Lack of practical procedures for revision of the MRP and treatment of imported goods on par with domestically manufactured goods even at the port of import render packaged commodities rules highly impractical, ambiguous, and prone to litigation. Now, revision of MRP, as I've already stated, if it is a revision of MRP where the MRP has come down, you have a process which we just discussed in one of the rules. However, if the MRP goes up, it becomes a little difficult for us to know what are the actual procedures that need to be followed, given that the item, the commodity has already been pre-packed. The other issue is with respect to goods that are being imported. It is difficult for an importer or a person who is actually trading in goods and goods abroad to know about the various provisions of the packaged commodities rules and to ensure that his commodity complies with the requirements of the packaged commodities rules. So many a time importers are hauled up for not following the rules. Probably, one suggestion is that enough time is given to these importers once they import the goods to be able to ensure that they are in a position to comply with the requirements under the rules by affixing the display, the sanitary declarations on the display panel, and by affixing the display panel to their prepackaged commodities. So right now we have a situation where importers are harassed because they're not being able to comply with the rules, more than for any other reason, for not being knowledgeable about the local laws. The other point for concern is the stringent penal consequences. So you have a situation here where the second offenses for not following the display panel, you have the second subsequent offenses where you can be liable for fine up to ₹1 lakh. So first offenses are compoundable, but second offenses can lead to criminal prosecution and could also lead to imprisonment. So this is something which is a cause for concern, if not for any other reason, because it offers tremendous discretion in the hands of the legal metrology officials to be able to pass a certain fine at a certain amount, giving a certain reason, which reason might not actually be the most justifiable reason. So where probably a ₹1 lakh fine needed to have been imposed, lesser fine would have been imposed, but the reasons for that would not be justified. Due to a stringent and complex compliance regime, the departmental officers show little sympathy towards the practical difficulties faced by industry, which very often results in unnecessary harassment. So departmental officers, many a time they don't understand the constraints under which the industry works, and there could be packaged commodities which have been which have come out of the factory and which do not have the particulars mentioned in the display panel correctly mentioned for one reason or the other. So it could be either a clerical mistake or it could be typo. So a printer's devil which crept in, and for all of this, that the departmental officers show very little sympathy. You have the main the officials in the company being hauled up. So this situation needs to be addressed in some manner. It is difficult to discuss in this session on how these situations can be addressed, but definitely there should be some way of having another forum where different ways in which this situation needs to be approached and addressed can be can be created, and further steps taken in that direction. There are many product-specific legislations which have their own set of labeling requirements, such as the Drugs and Cosmetics Act, the Seeds Act, the Food Safety Act, the Foreign Trade Policy, cigarettes and other tobacco products, product and labeling rules, etc. Each of these enactments have their own separate labeling requirements. Now, this makes it difficult for a trader, for a manufacturer to, check which of the labeling requirements he has to be, he has to follow. For example, the Food Safety and Standards Act would probably be applicable to a manufacturer who is manufacturing biscuits. So he would need to follow. You need to ensure that the Rule 6 of the packaged commodities rules are followed, and he also needs to ensure that the requirements of the Food Safety and Standards Act are also followed. So multiple legislations, multiple compliances extra effort and more cost. So probably there is some way in which this whole effort can be reduced and streamlined. This last but not the least, the principal, we just spoke about the principal display panel. We spoke about the statutory declarations that form a part of the principal display panel, and how the principal display panel has to be affixed on the package, which encloses the commodity. We spoke about all that. Now, earlier you had a very informal process where you had the legal department of companies, or you had the marketing and sales department of companies taking across the actual model of the packages to the legal metrology department, along with the display panel, and having it informally approved, by a letter from the legal metrology department. Earlier it was a so you have the legal metrology department, which could actually go through these products. It could actually go through these commodities and see if these commodities are following the rules mentioned, the package commodities rules. So basically, this is always the case under the Weights and Measures, the erstwhile Weights and Measures Act. One could just go to the Weights and Measures department and get it done, but the practice is now slowly changing, and there are very few departments under the Legal Metrology Act which today actually do this informal approval process of approving the display panel and approving the statutory declarations in the display panel, which actually exposes industries to a lot of non-compliance and to a lot of potential litigation. So the legal metrology department should, see if there is some way in which this informal process can be reintroduced, or if it is already happening in some centers, which is again a very welcome thing. If it is happening, this needs to be again duplicated in the other places as well, so that every other company is also able to go through this informal process and ensure that it is in compliance with the requirements of the packaged commodities rules and consequently the Legal Metrology Act. So with that, I think the monologue from my side is over, and I invite questions from the respected audience.